Have you ever walked into work expecting your regular shift, only to find out your boss changed your schedule at the last minute without warning? Maybe you were suddenly told to come in earlier, stay later, or cover a weekend you never agreed to. If that sounds familiar, you're not alone. One of the most common questions workers ask is, can my boss legally change my work schedule without notice? The short answer is, in many cases, yes. But just like with at-will employment, there are important exceptions and protections that may apply, depending on your state, your contract, or your union. In today's video, we're breaking down exactly what the law says about work schedules, when employers can make changes freely, when advance notice is required, and what rights you have if constant schedule changes are disrupting your life. Stick with me. Part 1. The General Rule under Federal Law, FLSA. At the federal level, the starting point is the Fair Labor Standards Act, FLSA. This is the main law governing wages, hours, and overtime in the U.S. But here's the key. The FLSA does not require employers to give advance notice of schedule changes. In other words, under federal law alone, your boss can usually change your shift without warning, as long as you are properly paid for the hours you actually work. For example, if you were scheduled for 9 a.m. to 5 p.m., but your manager switches it to 1 p.m. to 9 p.m., federal law doesn't stop them. What matters is that you are paid at least minimum wage for all hours worked, and overtime if you go over 40 hours in a week. This surprises a lot of workers because it feels unfair. And to be honest, it can be. Imagine you arranged childcare or planned a doctor's appointment around your original schedule, only to be told with no warning that your shift is different. Federal law doesn't address that inconvenience. It only looks at pay. There are also no federal rules that require a certain amount of hours between shifts. So, if your boss closes the store at 11 p.m. and schedules you to open at 6 a.m. the next morning, federal law calls that legal, as long as overtime and minimum wage rules are followed. However, and this is important, while federal law doesn't provide protections, some state and local laws do. That's where predictive scheduling laws come into play, which we'll cover in the next section. So, the bottom line under the FLSA is this. Your boss can change your schedule without notice, and it's generally legal, unless those changes violate minimum wage or overtime rules. That's why many workers feel powerless. But the full story depends on where you live. Part 2. Predictive scheduling laws in certain states and cities. While federal law is silent on notice requirements, several states and cities have stepped in with what are called predictive scheduling laws. These laws are designed to give workers more stability and advance notice of their hours, especially in industries like retail, hospitality, and food service, where schedules often change last minute. Let's start with Oregon. Oregon passed the Fair Workweek Act in 2017. Under this law, covered employers in retail, food service, and hospitality with at least 500 employees worldwide must provide workers with their schedules at least 14 days in advance. If the employer changes the schedule after that deadline, the worker is entitled to predictability pay. That usually means an extra hour of pay for added shifts or half pay for hours cut or canceled. This law was the first statewide predictive scheduling law in the U.S. Now, let's look at New York City. NYC has a Fair Workweek law that covers fast food and retail workers. Fast food employers must give workers their schedules at least 14 days in advance, and they can't make last-minute changes without paying a penalty. For retail workers, employers cannot use on-call scheduling, where employees must be available but may not actually get hours. This protects workers from being left in limbo. San Francisco was one of the first cities to pass a predictive scheduling ordinance known as the Retail Workers' Bill of Rights. Large retail chains must post schedules at least 2 weeks in advance, and workers are entitled to extra pay if changes are made with less notice. Chicago also has a Fair Workweek ordinance, effective since 2020, that requires many employers to provide 10 days notice of work schedules, increasing to 14 days after 2022. If schedules are changed with less notice, employees are entitled to predictability pay. Other cities like Seattle and Philadelphia have similar laws requiring employers to post schedules in advance and compensate workers if those schedules are changed on short notice. These predictive scheduling laws are important because they recognize how disruptive last-minute changes can be. Parents with childcare needs, students balancing classes, or workers holding multiple jobs all rely on predictable schedules. These laws don't ban changes entirely, but they make sure workers are either given proper notice or fairly compensated when changes happen. So, while the FLSA allows employers to change schedules freely, if you live in places like Oregon, New York City, San Francisco, Chicago, Seattle, or Philadelphia, you have extra protection. Employers in these areas can't just change your hours on a whim without either advance notice or extra pay. Part 3. Reporting time, pay and rest period laws in some states. Beyond predictive scheduling ordinances, some states have additional protections that limit an employer's ability to change schedules without warning. Two common examples are reporting time pay laws and minimum rest period laws. Reporting time pay laws require employers to pay workers if they are called into work, but then sent home early or their shift is canceled. The idea is simple. If you rearranged your life to show up at work, you should be compensated for your time, even if your employer doesn't end up needing you. For instance, in California, if an employee is required to report for work and is not put to work or is given less than half of their scheduled shift, the employer must pay them for at least 2 hours of work, up to 4 hours. So if you were scheduled for an 8-hour shift but sent home after 1 hour, California law says you should still be paid for at least 4 hours total. New York has similar rules under the state's minimum wage orders. Employees who report for work must be paid for at least 4 hours or the number of hours in their regularly scheduled shift, whichever is less. This prevents employers from calling people in only to send them home unpaid. Now let's look at minimum rest period laws, sometimes called right-to-rest rules. These laws prevent employers from scheduling workers for back-to-back shifts with little or no rest in between. One of the biggest issues here is the so-called clopening shift, where an employee closes late at night and then has to open early the next morning. In Oregon, the Fair Workweek Act gives workers the right to at least 10 hours of rest between shifts. If an employee agrees to work with less rest, the employer must pay them at time and a half for those hours. Seattle's secure scheduling ordinance also requires a 10-hour rest period between closing and opening shifts for covered employees. Workers who agree to shorter rest must be compensated at overtime rates. These laws exist to protect worker health and safety. Constantly changing shifts and lack of rest can lead to exhaustion, higher accident rates, and serious health problems. They also recognize the reality that many workers have family obligations, school, or second jobs that require predictable rest. So, while not every state provides these protections, if you live in a place like California, New York, Oregon, or Seattle, you may be entitled to extra pay, or even the right to decline, if your boss changes your schedule last minute in ways that disrupt your life. Part 4. Union contracts, employee handbooks, and company policies. So far, we've talked about federal law, state scheduling protections, and reporting time pay rules. But there's another major factor that can limit your boss's ability to change your schedule without notice: contracts and company policies. Let's start with union contracts, also known as collective bargaining agreements, CBAs. If you're part of a union, your work schedule is often covered by the contract your union has negotiated with the employer. Many CBAs require that schedules be posted in advance, sometimes 1 or 2 weeks ahead. They may also require that schedule changes be approved by both management and the union, or that workers receive extra pay for last-minute changes. For example, grocery store unions and healthcare unions frequently negotiate protections that guarantee predictable scheduling. If your boss violates these rules, the union can file a grievance on your behalf. Next, consider employment contracts for non-union workers. While most U.S. employees are at will, some professionals, such as nurses, teachers, or managers, work under written agreements. These contracts may specifically state how much notice must be given before schedule changes. If your contract says you must receive a week's notice, then your employer is legally bound by that term. Even if you don't have a union or a written contract, employee handbooks and company policies can sometimes create enforceable expectations. For example, if the handbook says work schedules will be posted at least 7 days in advance, that statement can be treated as a promise. Courts in some states have ruled that such promises can limit at-will flexibility, especially if employees rely on them to plan their lives. It's also common for large employers to adopt predictive scheduling policies voluntarily, even if they're not legally required. This often happens in industries where high turnover is costly. Companies want to keep workers happy and avoid being seen as unfair. In those cases, you may have more protection than the law alone provides. Here's a real-world example. A national retail chain agreed in a legal settlement to provide schedules at least 2 weeks in advance across all its stores. While not required by federal law, the company put it into policy, and employees can now point to that rule if managers try to make last-minute changes. So, the takeaway here is clear. Even if federal law doesn't give you a right to advance notice, your union, contract, or company policy might. Always check your handbook, your employment agreement, or ask your union representative. Those documents often provide scheduling protections that are just as powerful as state law. Part 5. Real-life impact, right to refuse, and when to take action. We've covered the laws and policies, but let's bring this down to real life. Sudden schedule changes don't just affect your work, they affect your entire life. Parents may scramble to find childcare. Students balancing classes may miss lectures. Workers with second jobs may lose income when schedules collide. And even without those obligations, unpredictable shifts can lead to stress, sleep problems, and burnout. That's why this issue matters so much. So, here's the big question. Can you refuse a last-minute schedule change? In most at-will jobs, the answer is technically no. Employers generally have the right to change your hours, and refusing to comply could be treated as insubordination. But if you are protected by a union contract, a state predictive scheduling law, or a company policy requiring advance notice, you may have the right to say no, or at least the right to extra pay if you accept the change. For example, in Oregon or New York City, workers can often decline unscheduled shifts without punishment. Another important point is retaliation. Even in states without predictive scheduling laws, you cannot be punished for asserting rights you do have. For instance, if you are denied overtime pay after a schedule change and you complain, the Fair Labor Standards Act, FLSA, protects you from retaliation. Similarly, if you request to time off under the Family and Medical Leave Act, FMLA, and your boss fires you instead, that's illegal. So, when should you consider legal action or filing a complaint? If you live in a state or city with predictive scheduling laws and your employer ignores them. If your employer refuses to follow its own written policies about posting schedules in advance. If you're disciplined or fired after exercising a protected right, like requesting FMLA leave or filing an OSHA safety complaint. In many cases, the first step is to document everything. Save screenshots of schedules, keep texts or emails where managers notify you of changes, and write down dates and times when your schedule was altered without notice. That paper trail can be critical if you ever need to prove your case. Finally, consider speaking with your HR department or a local labor attorney if sudden changes are creating serious problems. Sometimes a respectful conversation with management can resolve the issue. Other times, knowing your rights and being ready to enforce them is the only way to protect yourself. The reality is, unpredictable scheduling can disrupt your life. But depending on where you live and what protections apply, you may have the power to push back, or at least demand fair compensation. So, can your boss change your work schedule without notice? Under federal law, the answer is usually yes, because the Fair Labor Standards Act doesn't require advance notice. But that's not the whole story. Many states and cities like Oregon, New York City, San Francisco, Chicago, and Seattle have predictive scheduling laws that demand notice or extra pay. Some states also have reporting time pay rules and rest period protections. And don't forget, union contracts, employee handbooks, and company policies may give you even stronger rights. The key is knowing which rules apply where you live and work. If constant schedule changes are disrupting your life, you may have more power than you realize. If this video helped clear things up, hit like, share it with your coworkers, and subscribe for more plain English explanations of your workplace rights. And let me know in the comments, has a last-minute schedule change ever thrown off your life?